Hello, good morning, good afternoon, good evening, wherever you are watching us from. We want to say a very special welcome to today's episode of Sedat HR Digest, brought to you by Sedat Consult and JPEG Ghana Agency. You can contact Sedat's Consult for all your people and HR issues, and also JPEG Ghana Agency for all your designing, project analysis, and everything that concerns artwork. Please get in touch with them and they will sort you out. You can reach them on 057 187 0972, 057 187 0972. So 2 weeks ago, we looked at collective bargaining and labor relations. Last week, we looked at managing different generations at the workplace. And today, we are going to look at preventing strikes and lockouts, the role of unions. Preventing strike and lockout, the role of unions. If you come online, kindly drop your name in the chat box or say hi, and we would acknowledge you duly. And if you have any question, any clarification you want to seek in the course of the discussion, please feel free to leave it in the comment section. We will read it out for our guest or our resource person to answer you. Our resource person for today is not a new face here. He was with us last 2 weeks. He handled the collective bargaining and labor relations topic for us. And today he's here again, taking us through preventing strikes and lockouts, the role of union. He is a labor consultant, a mediator or an arbitrator listed with the National Labor Commission, an author of a book, 51 Rules for the Perfect Gentleman. And I believe when he comes on board, he's going to say something about his book because it's a very interesting one. Our guest is no other person than our very own Senior Ejabin. Senior, you are welcome.
Thank you.
All right, Senor. Before we go into our discussion for today, we want you to just say something briefly about your book, and so that those of us that are interested can get a copy and read it. I started looking at it, and Charlie, there are lots of stuff in there. So over to you, Senor.
Thank you very much. Good evening to everyone, yourself and everyone watching us. I thought would do the book thing at the end, but so far I have two books out. One of them is this one, Career Toolkit.
So Senor,
Toolkit for
we can do it, and then when we are ending to, we can do it again.
okay, all right. So, Career Toolkit for Successful Job Hunting is a career development book, and it has, in it all issues about job search, including how to prepare CVs and all that. And how it differs from other career development books is that this book tells you what to look out for in a contract of employment, how to negotiate a contract of employment when you get a job. So it goes beyond just getting a job to telling you what to expect in a contract of employment and how you can negotiate. And then the second one is 51 Rules for a Perfect Gentleman. Basically, it's a book for young adults, especially young adult males, and then parents and all other persons who are interested in knowing what a perfect gentleman should look like or should be like. It's a book that we released first quarter, last quarter last year, and so it's quite fresh. So basically, these are the two books, and anyone who needs a copy can always contact us, and then we'll ship one to them. And it's also on Amazon, so they can always go online, just search it on Amazon, and then they can purchase. Yes.
All right, so if you need one, you can get in touch with us. If you contact Sedat Consult, I'm sure we'll get in touch with Senior and we can also help you get one. Career Toolkit and 51 Rules for the Perfect Gentleman. Right. So today we have a lot to talk about and we don't want to waste much time. We want to go straight into our discussion. So we are looking at preventing strikes and lockouts, the role of unions. Right. So, Senior, sometimes you hear people say strike, other people are saying lockout, people are using it interchangeably. Can you help us distinguish the two? Is there any difference between strike and lockout? And if they are, what is the difference between the two?
Yeah, yeah. Basically, it's they're different, and strikes are normally what we'll say industrial strikes, and it is when um, employee representatives, that's the unions, lay down their tools and stop working or slow down work or decide to picket without working, etc., etc. That is an industrial action by the employee representatives, that's the unions, so employees and employee representatives. Lockouts are when an employer refuses to grant access to employees regarding the workplace. So employees might have done something and then the employer decides that nobody should come here anymore, maybe um, until further notice, stay away from this workplace without really going through the relevant processes and procedures to have that happen. So sometimes employers can deny employees of access to the workplace, and that will constitute a lockout. And that normally is a physical limitation. But with the um, import of or the introduction of a lot of technology in the workplace, access to the workplace is not only physical, it's also electronic. So when employees are also electronically denied access to their various workstations or workplaces online, it also would constitute a lockout. Yeah.
Right. So it means that strikes are usually initiated by the workforce and then lockouts by the employer. So please, if you are trying to get access to your company's systems and they are not going through, make sure you check and find out what is actually happening, whether it's a normal issue, technical issue, or there's some lockout trying to happen somewhere. Very good, Senor. In this case, we want to know, is it legal to go on a strike and who can actually call for a strike or a lockout?
Well, there's legal strike, of course, and there's illegal strike. And those who can call for a strike are normally the employee representatives who would notify the relevant, social partners on the other side. That's the employer and also regulators that due to certain specific reasons and factors, they are no longer going to work. What the technical terminology for the industrial relations terminology is they lay down their tools. So to lay down their tools means that they're not going to work. It is possible they may not show up at all at work, or they will show up but not work, or show up, work but not work in a manner that meets the standard requirements of productivity. And so then it becomes what we call the strike action in the workplace. So it's basically the employee, the union executives who are the relevant legal representatives of the employees and the officers, recognized officers of the unions. They would normally call the strike action, and it is often done communicated officially. Fine. Sometimes they don't even communicate it. You go to work and you realize the workers didn't show up, and then when you ask, they'll say, "Oh, they're on strike." There are some crude industrial actions like that. They they are at the table with you the day before, and certain decisions are agreed, and then the next day they don't show up for the workers don't show up for work. And when you call the executives, they say, "Oh, we are on strike," in view of the disagreements we had in yesterday's collective bargaining negotiation meeting or something, or standing joint negotiation meeting, and etc., etc. So yeah, the unions call the strikes, and they may notify and not notify. But when we get to the details, I'm sure we would know what really a legal or illegal strike means.
Why, thank you very much, Senior. So in this case, are there any signals that employers can pick up to say that due to these happenings, it means that there's a strike taking place, or workers can also say that due to ABC, we sense lockouts in the system. What are some of the signals or activities that shows that there is a strike or a lockout?
So for strikes, I think the first thing you would see in the workplace is red bands. You would see red bands hang all over the place, um, at the gates, and you find employees also putting on the red band. Now, once you see red bands, it means that there is some form of industrial action going on. The extent would be the only issue to get into. But the first thing you'll see is that you see red armbands. When workers want to declare strike actions or they are in the industrial action mode, first thing they'll do is to put on red armbands and hang red all over the place, just to signal to the employer that we are actually taking action against you in view of certain things that may be happening. So the red armbands are there. Sometimes the red armbands even come a week before the actual um, other industrial action processes take place. So red armbands actually constitute industrial action, whether the workers are working or they are not working, because they are acts of intimidation and they are acts of express signal to the employer. The second thing you will find is that work will either slow down or would not go on. Work will either slow down or would not go on. So workers may be at work and work would be so slow, especially when you are talking about maybe production lines or certain service oriented businesses. You will see that the workers are working, but they are working very lackadaisically. They are just slouching about, and what we call go slow. So they would just not be working to meet the production targets for that day, or the expected productivity for that day, or the number of days that they work. Third one, so they at work, they either don't work at all or they work slowly. That's the second sign. The third sign is that they don't show up at all. So they just don't show up for work, and they'll say they're on strike. So once an employer comes to work and no worker is at work, the red bands hang all about, then they know that there's a strike action. As for the lockout, it is basically one action that employees are denied access to their workstations, whether online or physical. So they come to the front gate and the gate is locked, often with security heavily in front, not allowing anybody to go into the workplace. And when they ask, why can't we go in? They'll say, ask your union executives, because there are issues that are to be dealt with before you can come to work. So these are some of the signs that a bystander or an average person will see in any workplace to know that there is an industrial action going on. Maybe I should add the third, that there's normally a lot of um, communication, press conferences, um, chanting of songs. I dare say war songs, but let's not use those words. But very strong, singing that would. But I've witnessed a strike action before where um, the workers played Palogo and Shijama the whole day at the work premises. So it was a go slow, and the drums were ongoing. So when you come and dance and you are tired, you go, the others will come. So yeah, all these normally would show that there's a strike action going on. Yeah.
Right, all these shows that there's a strike action going on. When you get to your office or you get to your premises and you see red bands all over, or you realize that people at work they are not working, what they should take like 2 hours to produce, you realize that the whole 8 hours is used to produce that particular thing. You should know that there's something cooking in your yard. Or when you hear of press conferences and chantings and sometimes emails, sometimes they drop one email and Charlie, you know that things are knocking things. Or on the side of the employer, when you get there, you are denied physical or electronic access, you should know that something is happening. These are some of the signals that when you see should alert you that something is happening or there is a strike or lockout taking place. So, senior, walk us through the various types of strikes we have in Ghana and then the position of the law regarding these strikes.
Okay, so this let me read from the Labor Act, um, Access 51, Section 175, which gives us the definition of what a strike means. And there it lists some of the types of strikes. So, strike means any action by two or more workers acting in concert, which is intended by them to restrict in any way the service they normally provide to the employer or diminish the output of such service with a view to applying coercive pressure upon the employer, and includes sympathy strike and those activities commonly called a work to rule, a go slow, or a sit down strike. So this gives us the various, basically the various categories of strike. So, like I said, we start from where the employee. So, first, the type of industrial action is the wearing and hanging of red armbands. Sometimes people think that because the people are wearing armbands but they are at work means that there's no strike. No, that action alone is an industrial action, and so it refers to a type of strike. So red armbands is a type of strike. Second one is that they are at work and then they decide to work, but they decide to work slowly. So it is called go slow, right? Yeah. So go slow. Go slow means that they are at work, but they would not work in a way that they are supposed to. They would delay the work. Then there's a work to rule, which also is like the go slow, but they do things to try to create difficulties for the employer, and in that make it difficult for the employer to bear the situation, and then give in to their demands. So a work to rule, for example, can be that they will come to work and some of them will stand, assuming you are dealing with a bank, some of them will stand somewhere in the front of the banking place with a red armband. And then I've not noticed some in work to rule in Ghana before, but this type before, but they will start talking to the customers of the bank who come into bank that, oh, we are on strike. We are not working because the employee has done A, B, C, D, and E. So it becomes very embarrassing for an employer. And that's a kind of work to rule. Basically, the work to rule is a way employees on industrial action would work to make the situation uncomfortable for the employer to be pressured enough to give into their demands. So then we have work to rule. They are at work. Then we have their work, they are not working according to how they have to work, or they are working, that is go slow, or they are working to make things more difficult for the employer and to pressure the employer more and to embarrass the employer. That is a work to rule. Then we have the sit down strike. And we have two types of this. The sit down strike can happen on the premises of the workplace or outside the premises of the workplace. So sit down strikes, for example, can happen where the employees get to work, but they would not work. They will not touch anything. They won't put on their computers. They will just not work. And they will be engaged in all other activities other than working for the employer, such as playing panogo and dancing and other things. In other activities, they can play games. They can do a lot of things. Strikes are interesting. The other one is that they can decide to stay away from work and be at home, or they can also decide not to be at work and not at home, but they may go and picket at maybe a regulator's place or a regulator's place or a higher authority. So maybe like the ministry. If it's a public institution, they know that it may not be their employers, their direct employers, but it may be issues coming from the ministry. So they may go and picket in the ministry instead of working. And that could also constitute a sit down strike. So these are the different categories and types of strike action that you can have basically in the workplace and within our laws. Yeah.
Right.
There may
Thank you,
be,
Senor.
yeah,
We
yeah. Go,
should
go
I
ahead.
go on? All right. So we have a question here from Ohima. Ohima says that should striking employees be paid when they strike, and should disciplinary action be taken against them?
Legal strikes are paid strikes. So legal strikes are paid for under our laws. But illegal strikes are not paid for, and they constitute um, a termination of the contract of employment, or they constitute a breach of the contract of employment to work. So, where employees are on legal strike, they are normally paid. But when they are on illegal strikes, then they are not entitled to be paid. So basically, that would be the section 168 of the Labor Act, Access 51, um, provides that where an employee engages in an illegal strike, they may not be paid or they may be terminated. So where employees are on legal strike, they get to be paid, but when they are illegal strike, they don't get to be paid. And since we
Right.
have a lot of illegal strikes in Ghana anyway, most of our strikes, maybe about 90% or 95% of them are illegal, then certainly they are not supposed to be paid. But often employers still do pay for one or two reasons. But yeah, these are the remuneration issues around strike.
Ohima, I hope we have answered your question. You can give us a feedback if you are okay. So if the strike or the action is legal, then it needs to be paid for. But where it is illegal, it is not to be paid for. You are not required to pay for it. And we will take this question and then go on break. And when we come back from the break, we would look at the role collective bargaining plays in preventing strikes and lockouts. So, Senor, walk us through or at what point, let me put it this way, at what point can employees decide that they are striking? At what point can they say that, okay, we are putting on our red bands and we are coming to work, but we won't fast track activities, or we are just going to picket somewhere and then chant and sing and dance logo. Maybe the next time they have to add Bobo to it. At what point can they say they are striking?
Well, from what we're saying, then at any point they can strike. At any point they can strike. As to whether that strike will be legal or not, that is the question to ask. So at any point they can decide to strike, and they often do that. At any point of a negotiation process, at any point of the year, the month, the week, they would just decide not to work, or they come to work and then they will not, work in a manner that they're asking for. But at what point can employees re- um, call a strike which is legal? So two key indicators um, differentiate a legal strike from an illegal strike. So for a strike to be legal, the first one is that within 7 days of the strike action, the union representatives are supposed to notify 7 clear days before. They are supposed to notify the employer and then the the National Labor Commission. They are supposed to notify these two persons or two institutions um, that they are going to embark on a strike action. The second indicator is that they would have to state the specific issues in dispute based on which they are embarking on the strike action. And for it to be legal, those specific issues must be pending, active, and justifiable issues that require that they may use their right to strike. Indeed, the strike action, or to take a strike action or industrial action against an employer, is a right of the unions. It's a statutory right of the unions. So let us not make it look like it is some um, out of nowhere action that these guys decide to take. But hey, they have a right to take strike action, but they need to ensure that they follow the procedures for strike or for declaring a legal strike. And that would often be to notify the National Labor Commission and also to notify the employer. The National Labor Commission, upon receiving such a notification, is supposed to act quickly to get the parties to the table and try to resolve the matter. If they're able to be successful in this, then the 7 days will not elapse, based on which then the legal industrial action can commence. But if that is not done, then of course they have the right to commence the industrial action, which will then be a lawful action or lawful industrial action or a legal strike. And then at some point, certainly they will be invited. But let me add this before I end this question. Thing is that when negotiations are going on, mediation, arbitration, or any process before the National Labor Commission, it is called a cooling off period, and you find it in section 161 of the Labor Act. And during cooling off periods, employees or unions cannot declare or go on strike. So if it is the cooling off period that they declare such a strike, then it is an illegal strike, right? So they may give the notice, they may do everything, but if negotiations are ongoing, or let's say they are before the National Labor Commission and they are going through a mediation process or an arbitration process or any kind of dispute resolution process, and they declare a strike action, then that also becomes an illegal strike. So The cooling off period is very important. Within the 7 days notice, if the National Labour Commission successfully calls in the parties to meet at the table before the National Labour Commission, then there will be a cooling off period for which they will have to call off the strike if they've started, or they cannot start the strike. Structure of the Labor Act and regulations around legal and illegal strike is such that it becomes very difficult to go through a legal strike in Ghana. But as always, there are ways around some of these things, and unions can still go through a legal strike around all of these issues. But that one is for us to be consulted and for them to be told. But otherwise, these are the general ways that legal actions, industrial actions can be taken. Yes.
All right, thank you, Senor. Ohima is back again. Ohima says that, can you please throw more light on illegal strike? What constitutes an illegal strike? We will take a break. When we come back, Ohima Senor will answer your question for you. All right, welcome back from the break. If you just join us, this is Sadat HR Digest brought to you by Sadat Consult and JPEG Ghana Limited. You can reach out to Sadat Consult for all your HR and people issues, and also JPEG Ghana Agency for all your designing and projects works. You can read them on 057-187-0972, 057-187-0972. And today we are discussing preventing strikes and lockouts, the role of unions. Before we went on break, there was a question which I promised when we return from break, our resource person would help us to answer that question. Michael, thank you for joining us. Matilda, thank you. Prosper, thank you. And of course, Ohima, thank you for your questions. If you are watching us on YouTube, LinkedIn, and on Facebook, thank you so much for tuning in. This is Sadat HR Digest. So, Senor, if you can hear me, can we answer Ohime's question? She says, can you throw more light on illegal strike? What constitutes an illegal strike? I think you have mentioned it in the course of the discussion, but probably you would want to re-emphasize it for her.
So basically, an illegal strike is a strike action that does not follow the laid down procedures under the law and also under the parties' collective agreement or any kind of agreement between the union and the employer. So where those processes are not followed, then there's an illegal strike. And I also mentioned that when a strike is called during a cooling off period, which is the time during which negotiation, mediation, arbitration, or National Labour Commission proceedings are ongoing, then of course parties cannot declare strike action. And if they do, then it's an illegal strike. So basically, the illegality of the strike action is that it is against the laid down procedures of law. And once that happens, it's an illegal strike. Once illegal strike is 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 declared by the National Labour Commission, having been notified and they satisfy themselves. Once they declare it, then the employer can take any action within the ambit of law against the individuals that are perpetrating the strike and individuals who also um, they instigated the strike. So those who instigated it and those who participated in it will all be on in line for either disciplinary action or more serious action against such persons. So basically, that would be what an illegal strike constitutes.
Right, thank you. Michael is giving a contribution here. Michael says, I think an illegal strike in the context of Ghana is when you go on a strike before the 7 day notice to your employers and the National Labour Commission elapses. And he quoted the Labour Act 651 2003. Thank you, Michael, for your contribution. And thank you, Senor. Senor, we want to look at our next question. Does collective bargaining play any role in preventing strikes and lockouts?
Yes, because for me, in many of the strike actions that occur, it is because collective bargaining went wrong, or collective bargaining did not take place at all,
Mm.
or the union was not entertained in the workplace. And so once collective bargaining is undertaken effectively, then there's likely not to be an industrial action, because it is when the relationship breaks down. Anytime the relationship breaks down between the employees and the employer, then you have, or in a unionized environment or not, then you have industrial action taking place. So basically, industrial action is a key indicator of the health of the relationship. Unless, of course, it's a sympathy strike, which normally sometimes the employer even encourages. But otherwise, it is normally a very difficult situation where the relationship has broken down and has become antagonistic. And so then unions are very quick to take such an action against the employer by using the phrase, we will advise ourselves. Once they say we will advise ourselves, then you know that something is coming. Yeah. So collective bargaining is important. If it is done well, it will often show or point to a fruitful relationship, and that normally would prevent strike actions. Yes.
If collective bargaining or your collective agreement is done well and solid, it will prevent any breakdown in your relationship. Right. So, within the present context of labor relations, how can unions position themselves beyond being seen as fighting for their members to becoming partners of the employer, being seen as fighting, and I mean now seeing them as partners to the business.
You know what the Labor um, Act 651 did to industrial relations is to raise the bar so high and to thicken the practice of industrial relations within our context within Ghana. And so, if unions um, understand and build their skills and knowledge in the new mechanics of industrial relations practice, then it will position them in a way to get what they want, rather than, you know, getting into all manner of problems when they have to go through the, call it the buga buga way, which is the strike actions and the lockouts. So there's something we call labor diplomacy. And in labor diplomacy, effective communication is used within the relationship to strongly advocate and negotiate a deal on any or all matters that regard the relationship between employees and their employers. So all these tools are available for unions to be able to actually learn and know. Again, because of the law, negotiation rules have changed. And Sitting around the table is not about how much you shout, it
Mm,
is about how well you advocate your point and persuade, using persuasive power to gain the confidence and trust and affirmation of the other side. So when unions traditionally go to the table, intimidate, bang the table, shout at people, bully their way through, then it becomes difficult for them to really get what they want. So what I would say is that unions would have to come to the table more prepared than they normally are. And I think that when this happens, it will help the process, and it will avoid them from using the hardest or the harshest ways of getting what they want. Because you know what strike actions do? They bruise relationships, and it takes a longer time to rebuild those relationships. Because during strike, just take how divorces are. Assuming um, a marriage couple decide to go through divorce, and then they go through the divorce to a point, and then they stop and come back. There is so much bruising that would have taken place that it takes a longer time to rebuild that
mm.
trust and confidence in each other to continue their relationship. So strikes are not necessarily a very good way of resolving disputes between an employer and employee, and must be the last resort, last resort, and possibly never ever to be used. But unfortunately, it is the quickest way unions normally would get what they want, and they'll tell you that is the language the employer understands. So they would use that. However, then it creates problems for the relationship going forward. So on their side, the unions need to be more prepared. They need to equip themselves and tool themselves more in terms of knowledge of the law and the technical processes of negotiations and industrial relations practice, so that they can be skilled enough to be able to make the best of the situation without running to strikes and lockouts. And I think employers also have a role to play in being more understanding and more open. And so if you're in a relationship and the other side doesn't seem to understand certain things and is not well um, well trained or well skilled in those things, sometimes you want to take the opportunity to help assist them to be trained so that they come to your level of understanding, so that the relationship will be more balanced rather than tilted halfway. So these are some of the things that I can say that the parties can look at in trying to enrich their relationships and to avoid strikes and lockouts as the quickest way of resolving their problems.
All right. So I think your last comment answered my next question. I was going to ask what are some of the practical steps that both parties can put in place to avoid tensions um in the environment that would lead to strike. But I don't know whether you would want to add some to it, but
Yes, it's good to mention this, that Section 108 of the Labor Act, if I can just get there and read it for you, it says
yeah.
provision for dispute resolution. Every collective agreement, that is contract of employment, shall contain a provision for final and conclusive settlement of any dispute or any differences between the parties to whom the agreement applies. So, first thing for prevention and what should be put in place technically is a procedure for dispute resolution, which should be agreed within the provisions of the collective agreement. That will say that when we disagree, we'll go through these steps, and when it fails, then we go to the National Labour Commission, etc.,
Mhm.
etc. When these processes are there, any party who wants to do a lockout or a strike action would have had to go through these processes, and failure of which, then if they declare a strike action, then it is an illegal strike action.
Yeah.
So the law provides that before we even start the relationship from the outset, let us have provisions for the conclusive settlement of all disputes that may arise in the future relationship, the future of our relationship. And for which then, when we get there and we disagree, we will follow. So that is a
Mm.
very key technicality of preventing industrial disputes by putting in place a technical process which will help resolve disputes rather than um, try to encourage strike action. Yeah.
Right, thank you. We have a question from Michael. Michael says, what is an illegal lockout? And he quoted subsections 2 and 5 of section 168 of the Labor Act. What is an
Yes,
illegal lockout?
certainly an illegal lockout is just as an illegal strike action. An illegal lockout is any process of lockouts that did not follow the laid down procedures. And the laid down procedures we've talked about does not only work for the unions when we talk about strikes, but also lockouts. So
Mm.
for a legal lockout, the notification has to be given. And during the cooling off period, lockouts cannot be entertained, by the party. So yes, Michael may be on point or on that one. That an illegal lockout is one that does not follow the necessary legal processes for declaring either strikes or lockouts.
An illegal lockout is one that does not follow the necessary legal processes. So, Senor, are there consequences for workers or employers that embark on illegal strikes and lockouts? I haven't really heard about consequences for lockouts, but are there consequences for employers too who embark on illegal lockouts? And by extension, the sympathizers that comes to give solidarity, should a strike be declared illegal and consequences declared, are they affected by that consequences?
Okay, so let me read section 1684 of the Labor Act, which provides for consequences for illegal strike. Without prejudice to subsection 2, a worker who takes part in an illegal strike may have his or her services terminated by the employer without notice for breach of his or her contract of employment, or may forfeit his or her remuneration in respect of the period during which he or she is engaged in the illegal strike. So the consequences are clear. You either lose your job or you lose your pay.
Mm.
And that is the first consequence. Second consequence is that where you go on strike and you go destroying property and undertaking any action that is classified as a crime under the Criminal Offences Act or the Criminal Code, you will be held liable for criminal prosecution. So these are the consequences of illegal strike. You open yourself up, and I have seen workers that ran to the Labor Commission for unfair termination, and Labor Commission clearly ruled that, hey, you were engaged in an illegal strike and you were terminated. So termination was fair. Employees who engage or participate in strike actions must think twice in
Mm.
understanding whether the strike so declared by their executives is legal or not. If it is not, then they are walking into a situation that which which conclusion they may not know, because you may be treading on dangerous grounds where an employer will just say, well, you are out, you are fired, you are terminated without notice. And that is acceptable at law. Under these circumstances, no court or tribunal can save you if you engage an illegal strike, which is so declared by the National Labour Commission. So consequences are dire, and I am not really for that sort of resolution process because, of course, I'm a dispute resolution professional, and we don't like to have disputes deepened by using coercive pressure and coercive action, because in the end, the relationship is scarred and it is more difficult to set it back on the right track rather than using dialogue and other alternative dispute resolution processes to mend the relationships when the relationships go bad. But strikes are not to be encouraged. Yes.
Strikes are not to be encouraged. If you embark on illegal strike, you either lose your job, you may lose your pay, and if you destroy any property, you'll be made to um, um, pay for it. So there's a comment from Michael. Michael says employers are liable to pay the unpaid remuneration of the workers in the case of illegal lockouts. Section 168, subsection 5 of the Labor Act. So, Senior, are employers required to pay for remuneration when they embark on illegal lockout?
When they embark on a lockout, employers normally don't pay the workers. So the remedy for that would be for the employers to pay the workers the remuneration that is withheld during the lockout. And if the lockout is legal, then of course they don't have to pay the workers. But if the lockout is illegal, then certainly they have to pay the workers. And and a, a court or tribunal would normally order that the workers be paid, their pay for which they were illegally locked out. Yes. So that is the position of the law. Yeah.
All right. So what happens to the sympathizers that comes to show solidarity in the case or in the event where the strike is declared illegal? What happens to them?
Or in terms of sympathy strike, the rules for sympathy strike is that the employer will be notified and the employer will decide what number of workers, for example, can go and support the striking parties as sympathy employees or employees on sympathy strike. Now, if the employees, and look at the technical side of this, if the employees ask for the permission to embark on sympathy strike or strike in sympathy with another party or a sister organization or a mother union, etc., etc., and that turns out to be an illegal strike, then clearly, under normal circumstances, they will be in line to be penalized by the employer against whom they went to strike,
Mm,
but in sympathy. But technically, that would not be their immediate employer, but they would have gotten permission from their immediate employer to go. So if the immediate employer does not check the the legality or otherwise of the strike action the sympathy strikers are asking permission for, and they grant them the permission. And of course, then I had the permission to go and participate in that strike. I didn't know it was illegal. So then it would be difficult for the employer having given permission to now turn around to say that you went to perform an illegal or to strike in an illegal strike. So, but assuming they went on the strike, the sympathy strike, and individual employees went to break glasses and break and destroy property and things like that, certainly action will be taken against them as individuals who came to illegally strike or
mm,
who came to perpetrate criminal action within the striking context. So the permutations of these things normally are not straightforward. On case by case basis, the law and the practice and the specific occurrences will determine what action should be taken. So, in terms of illegal sympathy strike, it's difficult, in my view, for the employer to who has given permission to now come and say that, hey, you went to take part in, assuming they didn't ask permission and they went, then that one is an illegal sympathy strike in the first place because they didn't have permission to go. So that one, they can be called out and they can be disciplined for those ones. If they are not lucky and they didn't ask permission and the strike they went to participate in is also illegal, then that makes it a double charge for which they will have to be dealt with. So yeah, the permutations are interesting and it's not just straightforward, a bit, complicated. Yes.
Right. So if you are going to sympathize, please make sure you are joining a legal one before you find yourself in trouble. All right. So we have some few minutes to wrap up, and before we end today's session, we want to find out what are the effects of strikes and lockouts on the business. What effects are there? I mean, when we are embarking on strike, lockout, what effects does it give the organization or the business? And why should we do everything possible to avoid it? Avoid
Okay.
strike.
Okay. So for me, I think that straight away the easily noticeable effects, that immediately play out. For example, a very bad strained relationship, bad communication, um, and then or difficult communication going forward, difficult relationships going forward, and then you also have where strike action takes place, a negative effect again would be reduced productivity or loss of productivity. And the loss of productivity is the biggest issue that normally would affect the business because if the business does not produce, it doesn't generate revenue. And if it doesn't generate revenue, then it's starved of resources to continue working. And
Mm.
then the organization can crash. Strikes are a danger to every organizational survival. So at all costs, it must be prevented as much as possible. However, there are the non-visible effects that you find that strike actions, um, kind of have, and one of them would be the strained relationships going forward. So people would say things and do things during a strike action and forget that they even said it. 2 years later, the people against whom they said it
Mm.
would then be taking action against them, right? Retaliation. And that retaliation will be based on things that happened years ago or months ago during the strike action. And they may not know that really that is where, such retaliation is coming from. Someone may think, why does my boss hate me so much? But they forget that maybe during one strike action, they gave an interview or spoke against their immediate supervisor in a way that got to them. So the strained relationships for me, and because I'm a dispute resolution person, we understand the impact of positive relationships in the workplace on productivity and the survival of the business. When teams are not working well, companies don't work well, businesses don't work well. So for that singular strike action that creates so much animosity, the effects and scars would be lingering and plaguing the organization for a number of years. And sometimes they cannot even pinpoint where the problem is coming from. It is dangerous. It has very long standing effects on business, and not only the productivity, but also the fruitful relationships that ensure that teams work better and collaboratively to increase productivity. So for me, these are some of the effects of strike action that we should look out for when we go through strike, and when we are when we are coming back from strike, or there's a word I'm looking for but it's not coming, So when we come back from strike, we need to take further action to make sure that we mend broken bridges properly and then put it behind us and move. Otherwise, it will haunt us continuously until it brings the business to its knees. Yeah.
Right, right. Strikes are dangers to the survival of every business, and we must do everything possible to avoid it. If not, productivity will be affected, revenue would be affected, strange relationships. I mean, you can't be in the office and build your own toxic environment around you. I mean, you'll be there, and when you are moving, you are watching who is doing what and that. Probably because of what you might have said earlier on when you were striking, which you have even forgotten about it. And so, anytime you want to strike, I mean, there's an adage in tree that says that when there's an issue, certainly you would have to talk about it. If you feel there's anything that is bringing tension between the relationship between you and your employer, please, instead of striking to affect a whole lot of things and at the end of the day the business suffering, sit and discuss and get it resolved amicably. If you are finding issues, that's why senior is there. He's a mediator. He will sort you out fast. Or senior.
Yes, sure, no problem.
Sure. That's why senior is there. So we want to take Senior's last words, and probably he would comment on his book again. Senior is an author of two books. Those of you who didn't join us uh, from the beginning, he introduced his books to us. I want him to do that again. The Career Toolkit and the 51 Rules for the Perfect Gentleman. Charlie, Senior, you have to do one for ladies. So
Yeah, I'm told, and I think I have to look into it and see what I can do. Since I'm not a lady, maybe do a joint one with somebody and so on. But let me end by saying that sometimes people think unions are terrible organizations and people, and they always are against an
Senior, let me
organization
interrupt
and
you
things like that.
one
Unions.
Let me interrupt you 1 minute. There's a question here which you can add to your final words. So, the question is, how do labor consultants such as yourself help in preventing strikes? So you can add that to it and then um, wrap up the
Okay.
conversation.
So, so I was just saying that unions are helpful in the workplace. They are process watchers. Just as in governance, civil society is a very powerful tool for forging proper relationships and bringing out issues that is necessary for preventing further deterioration of a relationship, or bringing out issues that can be discussed to prevent a lot of issues in the future. It's the same way unions play that kind of watchdog role in the workplace, guiding and helping management and the organization to do things better, and also to cater for its most important resources, that's the human resources, much more better. And at the end of the day, the union's contribution helps the organization. So unions are not necessarily bad. It is proven that indeed organizations with unions have higher remuneration than non-union unionized environments in the same sector. So yeah, unions are great. So we should try and encourage and use unions as a positive tool in the workplace to kind of thicken or make better the processes that we introduce in the workplace, and also to increase productivity. And as to what we do to help in preventing disputes, you have no idea. We get calls all the time. One party will call you, sometimes both will call you and sit with you, and then we help talk the parties through what they can do, about the difficulties they are facing in the employment relationship, the collective bargaining relationship, so that they do not. Sometimes they even invite us to sit as observers in their negotiation processes, and we help them to work around difficult issues in such negotiations, so that we prevent the disputes from happening. So yes, we are available to always work with parties that may need those kinds of assistance. And on the book, the two books, they are on Amazon. And so or you contact me, or you contact Sedat, and certainly we can send some to you. The 51 rules is 50 CDs. The signed autographed copy though is 500 CDs, but the copy, the shelf copy is 50 CDs. And the career toolkit, because it's targeted at young workers and also students, who graduate students, it is 25 CDs per copy. So get your copies, and then we can be in business. Thank you very much for inviting me and giving me the opportunity to share this um, little nuggets with you on collective bargaining. I wish everybody well. Thank you.
Thank you so much, Senor, for coming. It's been an insightful conversation, and I believe myself and all our viewers have really learned a lot today. Want to say a very big thank you. And if you are watching us, um, on YouTube, LinkedIn, Facebook. Please don't forget to like, share, and comment on all our social media handles. We will share the link of this discussion with you. So at any point in time, when you want to go back to listen to it, you can feel free to do it. And also feel free to share with your contacts. We want to also say a very big thank you to Sedat Consult for sponsoring us, and also JPEG Ghana Agency for helping to sponsor us. You can reach them on 057 187 0972, 057 Contact them for all your designing and project issues. And for SEDAT, you can reach them for all your HR, people, and then organizational issues. Thank you so much, viewers, for joining us. Thank you, Senor, for coming. We will meet you same time, same venue next week, and we are coming your way with another interesting topic. You wouldn't want to miss that for all the rise in China. Thank you so much for joining us.